this. Mr. Speaker, I beg to move that leave be given to bring a bill to amend the Employment Rights Act 1996 to provide that disclosures of information about malpractice to a Member of Parliament, where the disclosure is in the public interest, be treated as protected disclosure for connected purposes. In the last decade of the last century, one of the most important bills passed by this House was brought not by government, but by my honourable friend, the member for Aldridge Brownhills, with all-party support. His Public Interest Disclosure Act followed a series of accidents that were both fatal and entirely preventable, like the capsized car ferry at Zeebrugge, the explosion of the Piper Alpha oil rig, and the Clapham Junction rail crash, which between them cost 395 lives. In the 15 years since the Act was passed, British society has benefited hugely from the bravery of whistleblowers. Between them, these public-spirited men and women have shamed corrupt officials, identified heartless and hopeless hospitals, and exposed the deliberate or reckless misuse of public money. In the last 5 years alone, whistleblowers have exposed pharmaceutical companies which overcharge the NHS for drugs, alerted the National Audit Office to tax authorities agreeing sweetheart deals which let multinational companies reduce their tax bills by billions, filmed the abuse and neglect of elderly people in care homes, and exposed a whole litany of failings in our health service, some of which we've been hearing about. The appalling standards of care at Miss Staffordshire, failing maternity unit at Morecambe Bay, and fiddled waiting time figures at Colchester. Thanks to the Public Interest Disclosure Act, whistleblowers now have some protection. Employment tribunals have to date made 3,000 judgments in cases brought under that legislation. But these cases are just the tip of the iceberg. For every whistleblower who goes public with their concerns, many more never come to light. The decision to expose wrongdoing is a life-changing choice. Whistleblowers find themselves shunned by colleagues, bullied by bosses, and hauled before tribunals on trumped-up charges. Ugly rumours are started, careers are finished. Whistleblowers' health, wealth, friendship and marriages are tested to destruction. All casualties of acting in the public interest. Let me take just one example to illustrate the point. The story of Edwin Jesudason is typical. A paediatric surgeon with over 20 years' experience, he raised concerns that children had died unnecessarily at Alder Hey Children's Hospital. As a result, colleagues refused to work with him. Then trust bosses tried to force him out. When that failed, they tried to gag him, offering a six-figure sum if he left his job, kept his mouth shut, and destroyed incriminating documents. He refused the money. Last year, he sought an injunction to stop trust bosses sacking him. Halfway through the hearing, the British Medical Association suddenly withdrew their support. Near bankrupt, he had to drop the case. His case is shocking, but is not remotely unique. In April, a poll showed that more than 5,000 nurses who had reported substandard care, of them a quarter were warned against taking the matter further. Warned against taking the matter further. Half of whistleblowers face negative treatment of that sort, and a third of those are actually sacked. Faced with such treatment, or the threat of it, many whistleblowers admit defeat. Hundreds have been pressurised into signing compromise agreements, complete with gagging clauses which buy their silence. In the last 4 years, 77 NHS trusts used gagging orders to silence 133 staff at a cost of almost £4 million. This culture of secrecy clearly comes at a financial cost. But more objectionable is the unquantifiable impact on society and on our public services. The lives needlessly lost or irreversibly damaged. The unsuitable managers and staff allowed to continue in their posts. The missed opportunities to learn from our mistakes. That is the real cost of using public money against the public interest. Every time a whistleblower is dismissed, ignored, or bullied into submission, a cover-up is allowed to continue. That's why I welcome the government's decision to use the Enterprise and Regulatory Reform Act to strengthen legal protection for whistleblowers. But I believe we should go even further. In February, the Department for Business, Innovation and Skills published a document called Blowing the Whistle to a Prescribed Person, a list of prescribed people and bodies. This 22-page document lists the bodies a whistleblower can contact if they do not feel they can go to their employer. The list includes Revenue and Customs, the Independent Police Complaints Commission and the Care Quality Commission, but not the whistleblower's own Member of Parliament. That means that whistleblowers who report wrongdoing to their MP will not automatically be protected by law. Those conversations will only be protected if the whistleblower can meet the serious conditions set out in Section 43G of the Employment Rights Act 1996. These include notifying a potentially hostile employer, showing that the wrongdoing is exceptionally serious, demonstrating a reasonable belief that their employer will destroy vital evidence. If they cannot meet these sorts of conditions, whistleblowers who contact their MP place themselves at the mercy of employers who may want them victimised, sidelined or even sacked. I believe that is wrong. Whistleblowers should not have to consult a solicitor in order to be able to talk freely to their own Member of Parliament. That's why this bill seeks to do three things. First, it would ensure a whistleblower's disclosures to their Member of Parliament would be an unconditionally protected disclosure for the purposes of the Public Interest Disclosure Act. Second, it would make it a criminal offence for an employer to try and prevent a worker from blowing the whistle to their MP. There will be some narrowly defined exceptions, particularly over the Official Secrets Act, but even those exceptions could be overridden if the disclosure was clearly in the public interest. Third, it would empower Members of Parliament to refer allegations made by a whistleblowing constituent to a prescribed body. It would enable that Member of Parliament to require from any one of those prescribed bodies a confidential response. In this way, the bill would extend legal protection to whistleblowers' disclosures to their MP, but also ensure that any allegations are investigated by a body with relevant knowledge and experience. Whistleblowers often just demonstrate great courage, but they should not have to be heroes. Acting in the public interest should not require such a huge personal sacrifice. And employers who jeopardise public safety simply to save their own reputations should have to explain that choice in court. By shielding these courageous men and women from legal hurdles and vindictive bosses, this proposal will allow members of this House to protect everyone from waste, corruption and incompetence in business, in healthcare and more generally in public life.
Yeah.
The question is that the honourable member have leave to bring in the bill. As many of that opinion say aye.
Aye.
The contrary, no. The ayes have it. The ayes have it. Who will prepare to bring in the bill?
Sir Richard Shepherd, Sir Mingus Campbell, Margaret Hodge, Mr Stephen Dorrell, Anne Clwyd, Mr Dominic Raab, Mr Tom Watson, Dr Sarah Wollaston, Stephen Barclay and myself, sir.
Mr David Davis.
Public Interest Disclosure Amendment Bill.
Second reading what day?
17th of January 2014.
17th of January 2014. David, you okay? We now come to the opposition.